Hello, I'm Dominic Walker, JMW's Inside Man, and I'm with Jessica Stanway. Jessica is a solicitor in JMW's Commercial Litigation Department, and Jessica specialises in property litigation. Hello, Jessica.
Hi, Dom.
Hello, Jessica. So I know that you represent a lot of landlords with residential tenants, and one of the things that you specialise in is forfeiture of a lease. So what is forfeiture in a residential context?
Okay, so forfeiture in the context of sort of residential property refers to the right for a sort of landlord or freeholder to terminate a lease agreement, and it's usually sort of dependent on a default by a tenant or leaseholder. As you said, it is applicable to both commercial and residential leases, but there is a moratorium in place on commercial properties at the moment. So I think I'd prefer to focus on residential forfeiture, because although they are similar outcomes, the two processes themselves are really different. It's something which has been utilised in residential leases for hundreds of years, and what you would be expecting to see in a residential lease usually is a sort of clause or provision which states something along the lines of, subject to any default by the tenant in respect of any covenants in the lease or a failure to pay any monies owing under the lease, then the landlord has a right to re-enter the property. So this right of re-entry is essentially what we mean when we refer to forfeiting a lease. So it's sort of similar in nature really to a termination provision in any contract, but in this context, the contract is a lease.
So you mentioned about re-entry. Why would a landlord want to forfeit a lease? When's it used?
Well, I think if you think about any sort of block of flats, perhaps, or like a new build housing development, they actually sort of are small communities in a way. And the comfort of everybody in that building is very much dependent on everybody else following a set of rules. So those rules are set out in the lease. So some of them might seem a little bit silly on the face of it. For example, you might have a provision in the lease which requires you to have carpeting in your flat. And you might well think, well, it's my flat. Why should I have to have carpet? So perhaps you pull the carpet up and you just carry on. But now your downstairs neighbour can hear every single footstep, and suddenly they can no longer enjoy their flat because all they can hear is you. So what can you do as the downstairs neighbour? Should you just have to now put up with this constant noise from above? Should you have to bring expensive sort of legal action every time a neighbour stops following the rules? And I think that's one of the difficulties with blocks of flats that people forget. But one of the options that leaseholders often have in the lease is that they can compel the freeholder to then take action against the other leaseholders to enforce the terms of the lease. And one of those enforcement tools available to freeholders is forfeiture action. So although it's arguable that perhaps the freeholder could take other steps, and sometimes in some contexts those steps might be more appropriate, the finality of forfeiture sort of means that it can be very, very effective when enforcing a breach of lease.
And so you give a really good example there of where it might be used. What's your practical advice then for a landlord that wants to forfeit a lease for a residential property?
So the process of forfeiture is actually, in a residential context, is incredibly complicated. And that's because the concept of forfeiture of leases, it's been in existence for hundreds of years, as I said earlier. And because leaseholders potentially stand to lose their entire interest in the property in the event that a landlord forfeits the lease, quite rightly, statute and case law has developed over the years to try and offer protection to leaseholders. And I think this is where residential forfeiture definitely differs significantly to commercial forfeiture, because it's not the case that a freeholder or a landlord can simply just exercise its right to re-enter under the lease. So one of those key protections is that before a freeholder can forfeit a lease, that they are required to get a possession order. And that order will usually allow the leaseholder a period of time to remedy the breach. But even before you get that possession order, In the case of a breach or say service charge arrears, statute dictates that you're actually required also to obtain a separate determination or judgment that there's been a breach, and you also have to serve what is known as a notice before forfeiture and give the leaseholders an opportunity to remedy the breach within a sort of reasonable time. So by the time you even get to the point of contemplating forfeiture, you've actually already been through a considerable amount of litigation, and leaseholders have probably had significant opportunities to resolve the breaches. And it is actually very rare that you even get to eviction stage. But the way in which case law and statute has developed over the years is that there are certain things in the process that freeholders and leaseholders might not even be aware of, because it might be buried in some sort of case from 1874 or something. So I do just think it's one of those processes that is really difficult to sort of wrap your head around in a way.
Yeah, and that's where you're there to help as well. So if you'd like to speak to Jessica, get her advice on how to sort of navigate that minefield, you can contact her insideman@jmw.co.uk or call 0161 82 81 999. I'm Dominic Walker, JMW's Inside Man.